Hello, everyone. This is Annie Cartwright, an attorney in Husch Blackwell's Education Group. We're excited to share information today with you about technology transfer concepts for college and university administrators. Before we begin, I'll cover a few housekeeping items. At the bottom of your audience console are multiple application icons for you to use during the program today. I'll highlight a few of those for you. If you have questions during the webcast, please submit them via the question box. We'll try to answer all questions towards the end of the webcast today, but if a fuller answer is needed or we run out of time, we'll do our best to answer later via email. We truly appreciate audience participation and encourage you to submit your questions today. There's also an icon to assist with your viewing preferences. Note that you can expand your slide area by clicking on the Maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the Help icon. It has a question mark and provides information on common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be sent to you along with a certificate of attendance. The recording will be available for 2 weeks after the webinar. Joining me today are Michael Cronin and Denise Mayfield, attorneys in our law firm. Michael is a member of our Healthcare, Life Sciences, and Education group and has 12 years experience working with academic and medical libraries and biotechnology companies. Michael practices in the area of intellectual property and has a focus on patent issues relating to biotechnology, medical, pharmaceutical, and chemical technology. Denise Mayfield is also a member of our Healthcare, Life Sciences, and Education group and is a registered patent attorney with more than 25 years experience. She advises educational institutions as well as pharmaceutical and biotechnology companies in strategies for identifying, protecting, and commercializing their intellectual property assets. With that, I will pass the baton to Denise and Michael, our experts in the area of technology transfer.
Thank you, Annie, and thank you all for spending the next hour with us. To get started, I'll give an outline for today's discussion. The first topic we'll address is planning for inventions developed with research grant dollars. I'll give an overview of the basic technology transfer process and then turn it over to Denise, who will give you an overview of the Bayh-Dole Act, the seminal federal act controlling the rules and regulations for technology transfer. I'll then discuss policy supporting researchers, compliance, and fairness. We'll discuss an invention disclosure form, the role of patentability assessments, and monetary and non-monetary incentives for your researchers. Denise will then discuss trade secret and patent considerations, and we'll conclude discussing sustaining innovation and research at your institution, what has worked at other institutions. So understanding the tech transfer process. Fundamentally, university technology transfer is the movement of research and intellectual property from universities to industries. It is intrinsically linked to fundamental research activities in universities. For example, the National Institutes of Health had a budget of $32 billion for fiscal year 2016. That money all went out to federal research universities and institutions. In the 1960s and 70s, there was major concern regarding the lack of federally funded inventions being commercialized. In 1970, the NIH budget was $1 billion. However, very little of this funding led to commercialized products. This gap between funding and commercialized products led to the Bayh-Dole Act of 1980, which Denise will discuss in detail in just a minute. So conceptually, transferring an idea or invention, shown here as our light bulb, into a commercialized product or process requires the integration of agreements, such as joint development agreements, material transfer agreements, confidentiality agreements, with IP protection, whether that's through patents, trade secret, or know-how, with licensing agreements, setting forth the terms and boundaries of your relationship with your commercialization partner. All three of these have to work hand in hand in order to bring a commercialized product or process out to the marketplace, generating royalties back to the institution. So a few successes we may be familiar with. Gatorade out of the University of Florida. I was reading an article recently where the royalties paid to the University of Florida Trust recently exceeded $1 billion for Gatorade. Taxol out of Florida State University. Google from Stanford, and the vitamin D receptor out of the University of Wisconsin at Madison. With that basic backdrop, I'll now turn it over to Denise, who will give you an overview of the Bayh-Dole Act.
Thank you, Michael. So there are several reasons why technology transfer at a university or other teaching institute is done. The primary reason why technology transfer is pursued is because it's the law. In fact, it is federal law. Under federal law, specifically the Bayh-Dole Act, which we'll talk about in a moment, there is an ongoing duty to utilize federally funded technology. So it's a requirement that if federal dollars are received, that the receiving institution seek to commercialize that within the community. The second reason why tech transfer is pursued is for public good, specifically to assist in facilitating the translation of research to public solutions, public health, etc., in many different areas: energy, pollution, health, a variety of different problems that currently no solutions exist for. A third big reason why is to reward, retain, and recruit quality faculty. A phenomenon that's been observed with the creation of tech transfer is that the greater the technology transfer appears to be at a institution, it enhances the visibility of that institution, and with that becomes a magnet for good quality faculty. Tech transfer also promotes closer ties with industry, aligning the training institution or university innovation with specific industry needs in many cases. Tech transfer also generates university or training institution income. These research dollars can be used for promoting more research, as well as paying for overhead and more talent to the university setting. Lastly, one of the major reasons tech transfer is a positive aspect of a university life is it promotes economic growth in general to the institution. As Michael said, prior to 1980, federally funded technology awarded by the federal was awarded to the federal government institution, and those technologies developed were owned by the federal institution, not by the university. That all changed in 1980 with the enactment of the Bayh-Dole Act. Under Bayh-Dole, universities and other teaching institutions were now able to retain title to inventions produced using federal support. Not only that, but they were allowed to patent those technologies and then use them in licensing strategies to commercialize the technologies developed with those dollars. Bayh-Dole also requires several responsibilities on the part of the university or school. These include an obligation to share royalties with the inventors and to use those royalties for laboratory purposes, research, and education. The Bayh-Dole Act also requires these universities to make practical application of the funded technology, and specifically what that translates into is to actively promote and attempt to utilize funded technology toward a beneficial public use. Bayh-Dole also authorizes federal agencies to protect its own government-owned intellectual property, as well as to grant licenses for government-owned intellectual property, and in some cases, non-governmental-owned intellectual property with the exercise of march-in rights. Federal agencies are also permitted under Bayh-Dole to set restrictions on licensing and sublicensing by the university or teaching institute. For example, to create preferences for small businesses as well as preferences for substantially all manufacturing to occur in the United States. An additional requirement under Bayh-Dole is that it applies to all inventions conceived or first actually reduced to practice in the performance of a federal grant, contract, or cooperative agreement that's funded in whole or in part by the federal government, which is or may be patentable. So it applies even if there is a combination of private and public federal funds being employed in a research program. FIDO also requires the university or teaching institute to provide written agreements with its faculty and technical staff that requires the disclosure of any invention to the university, as well as which requires the assignment of inventions to the university or institution. FIDO also has a number of reporting requirements, the first of which is to report each new invention disclosure that is provided to them by a faculty or other employee within 2 months of having received that report. FIDO also requires the university or institute to elect to retain title to that invention within 2 years of having made this disclosure to the federal agency, unless earlier if a particular legal statutory bar applies. The most significant statutory bar that comes up in a university setting is the publication of a paper. 1 year after that paper is published, this constitutes a statutory bar to patentability in the United States. FIDO also has a requirement on the university or institution to file a patent application within 1 year of having elected to retain title to the invention, unless, of course, again, an earlier statutory bar applies. FIDO also restricts the institution from assigning the rights and the technology to any other party. There are 2 notable exceptions. One of them is that a university or institution may assign the technology and patents to an invention management company under particular circumstances, as well as possibly even assign the technology or invention to the inventor himself. This flowchart tracks the reporting requirements under BIDOL against the timeline of a typical grant received under the National Institutes of Health, or NIH. As you can see, responsibilities for reporting continues even past having reported the filing of a patent application. It requires the university or institution to also report efforts regarding licensing or other commercialization of the technology, as well as to report when other approvals are obtained from organizations such as the FDA. To facilitate the reporting requirements under BIDOL, the National Institutes of Health created the Interagency Edison Invention Reporting System, or what we've nicknamed iEdison. This slide provides you the website where you can access information specifically about iEdison, and the particular link is provided in your materials under the resource list. So iEdison was developed by the National Institutes of Health and allows governmental grantees and contractors to report via the web all federally funded subject inventions, patents, and utilization data to any federal agency that funded that research. iEdison also provides a question line email that I've also provided in these materials. You can also look up specifics regarding the iEdison reporting system at the Code of Federal Regulations at 37 CFR 401. So given the many situations when BIDOL does apply, there are at least 2 important situations where federal money does not require BIDOL compliance and all of the reporting that we talked about earlier. So when does BIDOL not apply to federal grant dollars received by a university, institution of higher learning? The first big example of when it does not apply is, for example, in the purchase of capital equipment, where federal dollars are used to purchase capital equipment, and that equipment is later used to recreate or reduce to practice an invention unrelated to the federal grant project. Perhaps it was created using funds from a private source, then BIDOL would not apply to that particular invention, where it was made without interference with or cost to a government-funded project. So in other words, all expenses in this example in making this invention involve only non-governmental funds, even though the piece of capital equipment that was purchased with federal funds was employed in the process. The second notable example where federal dollars received did not fall under BIDOL is where the federal grant money was obtained for educational purposes, such as a funding agreement made primarily for purposes under a grant from the U.S. Department of Education. This was specifically provided for by statute at 35 U.S.C. 2012 that recites no scholarships, fellowships, training grant, or other funding agreement made by a federal agency primarily to an awardee for educational purposes will contain any provision giving the federal agency any rights to the invention made by the awardee. This is an important exception to note where, for example, the institution is involved in creating improved educational programs or perhaps alternative teaching programs for its students. Michael will now discuss tech transfer from the perspective of a faculty employer innovator. Michael?
Thank you, Denise. Thank you. Now that we have a good understanding of what to do with our disclosures and the timing requirements of the disclosures, how do we get your researchers to give you the disclosures? Well, first, what are some of the disincentives to disclose? Or put another way, why would a researcher be reluctant to visit with a tech transfer official? First, researchers have limited time. They may have the belief they're better off preparing a grant proposal to secure additional funding for their lab. Second, the belief that disclosing the invention may cause a delay in publication or presentation. In a publish or perish world, any delay in the eye of the researcher may be too long. Third, the belief that discoveries should be openly shared with the scientific community, basically the belief that patents are bad. So to minimize some of these disincentives, technology transfer policy should provide researchers an efficient process for disclosing inventions in advance of publication, provide researchers with an avenue to quickly assess the scope of available patent protection. How does this invention fit within what's already known in the literature? Provide researchers with a quantifiable return on time invested. And finally, provide reassurances on dissemination of ideas. It's very important to let your researchers know that patent applications are published. They are made accessible. The scientific community can build off of that. And that fundamentally, if part of our research is to benefit the public, we have to bring it out to the public through commercialization. And that often requires some sort of protection around it. It's a necessary part to actually have that technology reach the public. Early discussions with tech transfer officials are important because international patent rights can be lost if a public disclosure of an invention occurs before filing an application. International patent rights can be essential for commercial success. Investors care, big pharma cares, big companies care. Having patent protection in the U.S. will certainly provide some value, but not having protection in major international jurisdictions such as Europe, Canada, Japan will certainly reduce the overall value of your IP. What constitutes a public disclosure? A publication of a research paper or abstract, a speech or talk at a scientific meeting, or even a poster presentation. For purposes of working with your researchers, we should take a very broad view of public disclosure, and it's anything that's made outside of a confidentiality agreement. While international patent rights may be lost by an early disclosure, U.S. law provides a one-year grace period. So for example, if we have a public disclosure on February 28th of 2017, we have 1 year to file our patent application in the U.S. or until February 28th, 2018. However, the public disclosure before a U.S. application filing will likely bar any international protection. So it's very important that we get our researchers visiting with us in advance of publication. So one mechanism to help researchers disclose to the tech transfer offices prior to publication or disclosure is a thorough and efficient invention disclosure form, a single document that asks a series of questions aimed at collecting all relevant information. This invention disclosure form considers the time constraints on the researchers and attempts to avoid the endless cycles of questions and answers. We want a one-stop shop, one form that will gather all information, that gives the tech transfer officials all the information they need to make a decision if they want a patent, and if so, it gives the patent attorney all the information she needs to draft that application. The invention disclosure form should provide the evidence for date of invention or creation and the names of putative inventors or creators. It asks a series of questions to obtain the benefits and advantages of the invention over that disclosed in the literature. Why can't we buy this reagent off the shelf? How is it better than something that's commercially available? We don't want to ask a broad question such as, how is this novel? We want to ask specific, pinpointed questions to elicit the novel features out of the researcher. You also want to ask a series of questions aimed at obtaining complete and accurate description of protocols and examples. When the tech transfer officials decide they want to file on this, the patent attorney will need all of this information. Having it at the outset will avoid the constant back and forth between the inventor and the patent attorneys, which your inventors will often find frustrating and an intrusion on their time. So if we can get it right up front and get all the information we need, it'll be a process that they can stand behind and they feel is valuing their time and respecting their other commitments. Finally, this invention disclosure form should be provided to tech transfer officials well in advance of any public disclosure. Recommendations. You want to consult with your institution's tech transfer officials before any public disclosure of the invention. Stamp confidential on every page of the technical portion of any grant proposal. This will protect disclosure under the Freedom of Information Act. And finally, use laboratory notebooks. Having all the information in one nice place will help your researcher prepare a very good invention disclosure form, which will then allow the patent attorney to draft a very good application. So one mechanism to quickly assess the scope of available patent protection is a patentability assessment. The patentability assessment provides researchers with an understanding of the scope of protection available. How does this invention fit with what's already known in the literature, in the patent databases? What really do they have? The patentability assessment will give you information to allow you to answer the question, how much time and financial resources should be invested to protect this invention? What do we really have here? A patentability assessment is an extensive search of the prior art that's conducted before the application is prepared and can aid in identifying the true patentable features of the invention. It's not required, but is recommended. No search is exhaustive. It can range from an inventor-initiated search on publicly available databases to an attorney-prepared patentability report. Most institutions kind of hit right in the middle there, where they will retain a third-party search firm to conduct a search, typically ranging from $500 to $1,000. And once those references come back, they're quickly forwarded to the inventors for feedback. How does your invention differ from this? This is the art we're going to need to get around to obtain a patent. So let's discuss it now. The drawback, it may increase your budget, but in my experience, it'll save you money in the long run. A search can help in defining the appropriate claim scope. You will be reviewing prior art that's, if not identical, it will be very similar to the art the examiner will be considering. This allows you to tailor claims up front to distinguish over the relevant prior art. This will reduce prosecution cost and time and avoid prosecution history estoppel, a legal doctrine that limits your claim scope based on amendments made in the face of examiner office actions. So we know what we have is an invention. We know what we want is an issued patent. but how to get there is not really defined. The patentability assessment can be your roadmap. It'll tell you what roads to take and what roads to avoid. And it really gives you a very good overview of how to get this invention patented. In addition, a search can actually strengthen the patent. You'll identify relevant prior art for the examiner to consider. It's more challenging to invalidate a patent based on a reference the examiner considered during prosecution. So by getting the closest prior art and submitting it to the office, whatever comes out from the office will actually be a stronger patent. In addition, and very importantly, the inventor understands what they can expect to receive. This avoids unmet expectations in the future. We don't want to promise the moon and the stars and then not be able to deliver. So right at the outset, you'll say, this is where we think we have room to work. This is what we think we'll be able to get. Now, given that, is it worth the time and the money to pursue that? So everyone knows what they're getting into at the beginning as opposed to 3 or 5 years later down the road. Finally, technology transfer policy should provide researchers with a quantifiable return on time invested. We should consider both monetary incentives and non-monetary incentives. As Denise mentioned, the Bayh-Dole Act requires universities to share proceeds from the licensing of patents with inventors. However, there are no regulations on how much revenue should be shared with inventors. Institutions typically set out the portion of the revenue for the inventors as a group. So for example, if the institution decides that 10% is a fair number, that will be set aside to the inventor group. Whether there are 2 inventors or 4 inventors, that group will get 10% to split. Locke and Shankerman, back in 2003, conducted a survey of 102 universities, and they found that the average share to the inventor group was 41%, with a range from 25% to 65%. While this study is getting a little dated, it's still the most comprehensive study that I was able to find. The survey found a positive correlation with the amount of licensing income a university receives with the percentage of licensing income paid to the inventor. And in a fundamental level, this makes sense. If you're willing to share more with your researchers and your inventors, they'll be willing to invest more time with the Tech Transfer Office. So just looking at one example, the Stanford Office of Technology Licensing, a well-established and prolific licensing unit, net cash royalties are divided 1/3 to the inventor, 1/3 to the inventor's department, and 1/3 to the inventor's school. And I really like this approach. It's an approach that's pretty gaining a lot of momentum. Not only are you sharing a percentage with your inventor, but 1/3 is going to the inventor's department, which are their closest colleagues, their friends, people that may buy, you can buy equipment that's shared. So there's a direct benefit. If, for example, the inventor was in the Department of Bacteriology, 1/3 would go to that department, which allows for shared resources. And then 1/3 would go to the school. Here in Madison, the Department of Bacteria is in the School of Agriculture, so 1/3 would go to that school. So you're keeping the proceeds to their closest contacts, which increases your incentives to spend your time working with the Tech Transfer Office. Non-monetary incentives. Recognition and tenure assessment, right? The number of applications filed can be a factor in tenure consideration. In addition, the patent publication can be credited as an academic publication. In many academic institutions, the degree of publication is a major factor in engaging how a researcher is doing. Well, by crediting these applications, these patent applications, as a publication, tells them that it's valued, because oftentimes one of their major criteria for advancement is number of publications. So by tying the patents to that, you actually are telling them it's important. Intellectual freedom. You want to make sure that there's no restriction on research or requirement for collaboration with industry. Oftentimes a researcher may be reluctant to file on an application because they think it's going to pigeonhole them in that one specific area or on that one specific question. Letting them know that it's just one project in the lab, There will be no requirement to pursue that if their academic interests go elsewhere is very important. And then finally, recognition by peers. Something as simple as a department newsletter that provides names of the researchers contributing to filed applications can go a long way. There's immediate recognition amongst your peers and colleagues and lets them know my school, my department values this. So it's about making sure they understand the time that they're investing in this process is actually rewarded and valued by the institution. So with that, I will turn it over to Denise, who will tackle patent protection and trade secrets.
Thank you, Michael. So to create commercial value, a technology must be legally protected against unauthorized use. Otherwise, people would just use it for free and no commercialization funds or movement to the public would occur. The primary vehicles used to secure these legal protections are either, one, patents or trade secrets. So how do you decide which vehicle to use? Well, let's first look at what are the requirements to obtain a patent to your technology. So one of the primary requirement to obtaining a patent to the technology is that it be new or novel, not already known. This includes having never been previously published in a scientific journal article, poster, or other public presentation. Additionally, that technology must not be obvious. This is a strict legal definition of what obviousness means under the patent law, not a scientific obviousness assessment or standard. The invention must also have some sort of useful utility. This is a relatively low bar, apart from some alternative issues that have been raised regarding utility in the biotechnology area. We can talk about that at a later point. The invention must also be subject to a sufficient written description to provide the details of the invention. In addition, you must be able to enable what that invention is, meaning you must be able to provide specific details on how to make and use the invention. Lastly, your patent must provide the best mode of practicing the invention. That is, the preferred way of practicing that invention that was known to the innovators as of the date that that application was filed. You can't hold back any secrets as part of the patent application. That's part of your deal with the government in getting this limited monopoly we know as a patent. However, under the America Invents Act, failure to disclose best mode in a patent is no longer a basis upon which to assert invalidity of that patent, which makes for some interesting conversation. Oops, went too far. This slide provides an overview of the events leading to, hopefully, the issuance of a U.S. patent. The first event you see here is the filing of a U.S. provisional application, followed within 1 year by the filing of a non-provisional application. You may or may not decide to file a provisional application, in which case you can jump right to this second bar that says 12 months. A non-provisional application will expire by operation of law at the end of 12 months, and this is why you must make a subsequent filing either in the U.S. or perhaps in an international case under a PCT application. An important time point on this flow chart is this 18-month publication issue that you see here. At 18 months, your patent application, whether or not it is allowed, will be published and made publicly available to whoever wants to see it. So consider this in deciding what strategy you decide to select for your technology. Once the application is filed as a non-utility application, the period known as patent prosecution occurs before the United States Patent and Trademark Office. Basically, this is a period of back and forth negotiations between the patent examiner assigned to your case and your patent attorney. As noted here, it can take anywhere from 2 to 5 years, generally greater than 3 years, sometimes much greater than 5 years, just depending on the complexity of the technology and the backup at the U.S. Patent and Trademark Office, of course. Once you've negotiated allowable claims with the Patent Office, your patent will issue and will remain active as a patent for a 20-year term. This 20-year term will be measured from the date on which the non-provisional application was filed, not the date on which the U.S. provisional application was filed. A frequent misconception. So now let's look at what a trade secret is and what is required to obtain trade secret protection for your technology. Well, the very first requirement, of course, is that whatever you are calling proprietary must be a secret. The formal definition of a trade secret is information included in a formula, compilation, program, device, or method that derives independent commercial value, actual or potential, from not being generally known to competitors, and that is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So this is a very broad definition. The primary issues to consider here are, and that come under question many times, is what constitutes reasonable efforts to maintain secrecy. Some of the elements that I've looked in evaluating the relative measures being made to maintain secrecy are the existence or absence of policies, specific guidelines within your organization that requires employees to maintain certain confidences, perhaps policies that only provide for the disclosure of information to a limited of need-to-know employees, and those sorts of controls within your own organization. Also, the particular efforts that are made to maintain security of that information, whether it be in physical means such as a vault, multiple lock systems, the existence absence of an armed guard, and what have you. Electronic measures taken to maintain security, including the alarms, perhaps like bioidentification, access to particular secrets that might be being maintained, electric sensors, and whatnot. In addition, the existence or absence of agreements within your institution will be considered as reasonable efforts or not. Do you have employment agreements in place that require confidentiality among the employees? And do you always make sure that before you discuss a alleged trade secret that you have a sufficiently strong confidentiality agreement in place with the party you're negotiating with? So given this specific overview of patents and trademarks, let's look at some of the major differences between the two and deciding which way one would like to go in protecting their technology to make it a commercial asset. Patents, as we discussed, have a definite 20-year term and then it expires. No more action under the patent can be used to preclude another from using that technology. Trade secrets, on the other hand, provide indefinite protection, well, as long as you keep it a secret. Side note there, one particular disclosure of that secrecy will immediately destroy your trade secrets, giving credence to the loose lips, sink ships mentality of keeping a trade secret. Patents provide you an exclusive right to the technology that's identified in the patent claims, within the metes and bounds of your patent claims in your patent. In contrast, trade secrets are relatively non-exclusive. Anyone else is free to reverse engineer or independently develop that technology without recourse to the person who holds that particular trade secret technology. Another difference between a patent and a trade secret is that patents provide only a limited scope of subject matter protection. And as I mentioned before, this subject matter is only that subject matter which is within the metes and bounds of the claim that actually issues by the patent office in your patent. The negotiation back and forth with the patent office we talked about before. In contrast, a trade secret has a relatively broad interpretation of scope. Again, as long as it is maintained as a secret. There are no claims, there is no reference to a particular outline or structure that would bind your trade secret to a particular construction of scope. Let's look at cost. A patent can cost anywhere from $20,000 to $50,000, depending on the complexity of the technology, and sometimes in very complex technologies, even above $50,000. In contrast, a protection system for trade secrets can vary widely. It can be simply placing the particular trade secret information in a locked cabinet, or it can be as extensive as providing the electronic sensors and armed guard sorts of situations that we talked about earlier. For patents, it takes about 36 to 45 months before you will ever get a patent to issue, and you have to wait until that actual patent issues in order to sue another person for infringing your patent, in most cases, with a few exceptions. On the other hand, trade secret protection is immediate, and you don't have this waiting period for someone to approve or disapprove what it is you have identified as your trade secret. Trade secret continues to gain momentum in this country as a mechanism for protecting technology, as evidenced by the recent enactment of the Defend Trade Secrets Act of 2016. This particular act was signed into law on May 11 of 2016 and provides a federal cause of action under a trade secret misappropriation of information. This act provides for a 3-year statute of limitation and provides for an ex parte seizure of materials and information in extraordinary circumstances, so it does have some significant teeth to it. A 3-year statute of limitation applies, whereby the particular holder of the trade secret has 3 years in which to bring a cause of action against an alleged misappropriator under the Deceptive Trade Secrets Act. The Deceptive Trade Secrets Act also provides for whistleblower protections. These are basically protections to an employee who has a need to disclose information to an attorney or other government official to alert of a suspected violation of law or violation of law. On balance, given the distinctions that we've talked about, patents perhaps seems to remain the better vehicle in a university setting or teaching institution for protecting your technology in a tech transfer effort compared to trade secrets, absent any extraordinary set of facts or licensing preference. Now Michael will conclude with remarks on sustaining innovation disclosure from faculty and employees. Michael?
Thanks, Denise. So, sustaining innovation at your institution. Obviously, we don't have any secret sauce or a crystal ball, but we thought we'd share a few things that have worked at other institutions, and of course, it'll depend on your specific culture and your specific set of facts, but these are just some things that we found have been pretty successful. The culture of an institution is one of the strongest and most pervasive influences on technology transfer and commercialization performance. This includes incentives, rewards, and leadership from presidents and chancellors to tech transfer officials. So it really comes from top down, from setting the culture. If we're going to put an emphasis on this innovation, it's really going to be a top-down dissemination. Some examples of institutions that have done a nice job of this include the University of California at San Diego, MIT, UPenn, and Washington University in St. Louis. Many of these institutions provide their professors and their researchers opportunities to have part-time appointments with the academic institution and a part-time appointment with the startup company or the company that they founded. So they don't make them choose. They allow them to pursue both passions, and they figure out ways to make it work. Institutions with strong tech transfer programs place great emphasis on obtaining federal research dollars. This often results in strategic targeting of core competencies. So one such example is the University of Wisconsin here in Madison that back in the 90s made a concerted effort on obtaining funding for stem cell research. This funding led to a lot of innovation, many patents, and several companies have now spun out from that. Now the UW-Madison is one of the leaders in stem cell biology, not only in the U.S., but the world. And that was really a targeted initiative securing the funding for this one specific area. Institutions often facilitate access to seed capital, and management services to build capacity in startups. So many of our researchers are very good at what they do. They're probably leaders in their field, but they've never developed a company. They've never started a company. So they're going to need some guideposts along the way to help them do the things that need to be done, starting from raising funding to building a management team to building out a business plan. These are things that they can certainly tackle, but they're going to need guidance in order to do that. Incubators and research parks can help create an entrepreneurial culture. So you can get a lot of synergistic effects by having the researchers in one area. Not only do you have these startups in one collective area where they can bounce ideas off each other and they're all kind of going through the similar trajectory and similar guideposts, but you also have logistical effects that they can share very expensive equipment such as centrifuges or very expensive electron micrograph microscopes. It's just not only do you get ideas being shared, but you can actually share reagents and equipment, which makes it much easier to get started. A couple examples doing really good things: the Purdue Research Park, Southern Illinois University Research Park, and TechNest recently started out of the University of Illinois. Programs aimed at building core competencies can aid in establishing an entrepreneurial culture. So one thing that's worked quite well are business plan competitions. Provide a friendly forum for researchers and inventors to start to figure out how do you write these business plans. Constructive criticism is provided, and for the winner, there's usually a monetary award of between $50,000 and $100,000. So well worth their time, and they get a ton of constructive criticism. Mentoring programs. As I said, many of these folks are very experienced and leaders in their field, but this is something they've never done. They need someone to kind of help them navigate this, tell them what has worked, and more importantly, tell them what has not worked. And then finally, CEOs and residents. Many institutions have sabbatical programs. Well, now what's becoming popular is allowing your researchers to spend time inside a company, inside big pharma, where they can gain valuable business experience and management experience. So these are just a few ideas that the tech transfer community has found to be pretty successful and should be considered. So in conclusion, based on this talk, I think we can all agree technology transfer is a complex process with many facets. Denise and I kind of viewed this talk as a survey course, so to speak, where we tried to touch on some of the major high points, but there's many evolving topics that we simply didn't have time to discuss. One of which is patentable subject matter in the biotech arts, which is an ever-changing landscape based on some recent Supreme Court decisions. Determination of inventorship, which is often very difficult for tech transfer officials and organizations, because the mentality of a researcher is that everyone who contributed is placed on a paper. Well, that's not true with a patent application. There's a legal determination of inventorship, and it's very important that you get it right. And this can often create some political issues within a lab and certainly within an organization. Technology transfer to a startup. It's one thing to out-license your technology to a big established company, and it's a whole other thing to out-license it to a startup. There's different considerations. How do you get the technology back if milestones aren't met? What do you do if they're floundering? There's a lot of things you have to consider when working with startups. Best practices in licensing agreements and joint development agreements. These are pretty complex agreements that set forth a lot of parameters that are critical for success. So if any of these topics are of interest, just feel free to let us know. We'd be happy to do another seminar in the near future. Denise and I are both on the road quite a bit, and if there's something we can do for your organization and specifically, we'd be happy to set up a time to visit with you. And with that, I'll turn it back to Annie, who will guide us through the conclusion of this.
Thanks so much. It looks like we've had a couple of questions from our audience members, and we have a few minutes, so I will convey those questions to you. Our first one is, we're not a major research institution with a technology transfer office. How do these concepts come into play for schools like that, and what can we do to implement technology transfer best practices?
Hi, this is Denise. Actually, this is a topic we visited on right before the talk. If your institution or training school receives any kind of federal money from, for example, not just the NIH, but perhaps, the Department of Defense, the Department of Energy, or any one of a number of federal organizations under that, those funds will typically be administered by somebody at your institution, and what I've seen is that they get administered by your contracts person on campus. Perhaps if you've got an administrator, a head administrator, they're going to be asked to, in most cases, assist in the handling of those particular monies. So it's important that from top down, whoever the person is at your organization that has applied for federal money, that they be in contact with that administrative office or person, whoever it might be. And this is how you can start to become involved in tech transfer. Actually, I'm going on 29 years doing this, and at that beginning time, nobody had a tech transfer office. So it's a relatively new phenomenon. And this is how I saw them begin to create that particular function within their organization. They've worked out with their contracts people, if you have a contracts office, and looked around at what the technology, if it was for research and development, what is it that they're looking to develop? And through that, identify, well, did you come up with something innovative? And if you did, this is your start to innovation and identifying what it is you might capture as a commercial asset for your organization. So that would be my not-so-short answer to the question. Michael, any comments?
No, I think that was a great answer. I think you hit all the points.
And I see we have another question as well. What if we have federal and non-federal research dollars in play in the same research project? How do we balance requirements of the two and rights under both?
Actually, that's another question we talked about. If you'll recall, the law under Bayh-Dole applies whether or not the federal funding provided was in whole or in part used in the creation of an invention. So under your scenario, the Bayh-Dole reporting requirements, whatnot, would apply. Not knowing what the competing interest on your non-federal funding was, it's difficult to answer specifics of what you might do in considering a balance, but definitely if that technology amounts to something that is or might be patentable and was created in whole or in part using federal money in conception or reduction to practice of whatever this thing is you now have, then Bayh-Dole will apply. Michael?
No, yeah, I think that's absolutely correct. I think it's the age-old adage of tracing back the dollars. So in this case, if you know some of the money has come from a federal agency, then Bayh-Dole is certainly going to be at play. And if some of the money has come from a non-federal agency, such as maybe the Bill and Melinda Gates Foundation, they often have their own requirements for reporting and invention and ownership and those sorts of things that are outlined when they send you that you've been awarded. They often send you the grant or the contract that you have to abide by. So it's really looking at where the money came from and what are the requirements for those two agencies. What we discussed today would handle the federal side. For the non-federal side, it's really looking at what's come from, where the money has come from, and what are their requirements. The good news is that you can have multiple owners of a patent application. You don't have to choose just one. In this case, it's very likely that the owner could be, the federal agency would assign the rights to the university, and then the other owner would be the Bill and Melinda Gates Foundation. So you don't have to choose just one, you just have to make sure you're keeping both parties in the loop and that we're following the guidelines that come with that money.
But remember, money from the Department of Education does not apply to Bayh-Dole.
Thank you very much to both of you. Those are our questions for the day. I want to again thank Michael and Denise for sharing their expertise on technology transfer with us, and thanks to you participants for joining our program today. We hope the information we provided was helpful to you and your organization. I want to remind you that this program has been approved for Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. In order to get the certificate, if you need one for your state, you must click on the CLE icon to report your attendance. That's at the bottom of your screen. If you haven't already, please also click the survey icon at the bottom of your screen to complete our short survey. Your feedback really does assist us in providing quality program and future webinars. A recording of the webcast will be available tomorrow for watching and sharing, and will be available for 2 weeks after the webinar. Along with a copy of the recording, a certificate will be emailed to you. Please be sure to join us for our next webinar on Wednesday, March 22nd, regarding the university and college compliance obligations under the Foreign Corrupt Practices Act. This concludes our webinar. Thanks.